Great. Thank you so much, Professor Bronin, and thank you and the GW crew who's putting on this amazing event, and thank all of you who are sticking with us on a Friday afternoon, this intrepid and stalwart group here listening to a discussion about the environment, and specifically about how paradigms are shifting, and they're literally shifting like before our eyes, it felt like in that earlier conversation. Bill, once that
No, I'm just
turned
wondering,
off,
once we get going.
does that bother you?
Well, just, none of us are using it, so I don't know.
Okay.
It doesn't matter.
Okay, sorry.
It's
Well,
all right.
anyway, we're not going to use slides. So if there's somebody in charge of that and you all wanted to go with, that's fine. It's fine with me to have it up there too. Okay, so I am Vicki Arroyo. I'm a professor from practice at Georgetown Law, and until the end of 2024, I also served in the Biden administration as the associate administrator for policy for the 4 years of that administration on leave from Georgetown. And of course, the paradigms have really shifted since then. In this last year, we have a great panel to discuss the environmental paradigm shifts with me, and hopefully this intrepid and stalwart audience that I referenced earlier will join in this afternoon. As I think about what has shifted, I think about things like the sea change, given the rollbacks on environmental justice, with a legend right in front of me, and air toxics regulation, on climate commitments, and the all-of-government approach to tackling climate change that we heard about earlier today, certainly our engagement internationally as a country, and of course, given last week's announcement of the repeal of the endangerment finding and the vehicle regulations, to our own ability to tackle the greatest challenge of our time, climate change. And before inviting our distinguished panelists to share their thoughts, I'll just mention two well-established paradigms that have been flipped on their heads, in my view. One is the traditionally bipartisan embrace of cooperative federalism, and second is the use of the Congressional Review Act for rules but not adjudications. In previous administrations, whether it was the Bush-Cheney era or Trump's first term, we saw states playing vital roles in climate and clean energy policies and leadership. And while many states and cities are continuing with their efforts to address greenhouse gas pollution and prepare for climate impacts, you might have seen the nice story that Maxine Joslow wrote this week in the New York Times on that. These efforts are also being targeted by the Trump administration. So we're seeing those attacks. We're also seeing, of course, the rollbacks on the assistance, the financial assistance that those states and localities were getting through IRA and other funding. We're seeing threatened preemption of state regulation, even lawsuits to try to fend off state climate superfund litigation. Given the vacuum being left on climate change, should this administration's rollback succeed, I would argue, as I do, if you want to see in a recent American College of Environmental Lawyers, or ACOEL blog, that there's really no one occupying the field if this all happens and comes to pass, and indeed the Supreme Court might overrule Mass versus EPA, so that other opportunities, such as common law lawsuits, nuisances, state legislation, state regulation, local approaches from zoning and land use to transportation possibilities like congestion and pricing systems, as we see in New York, might fill the gap. But of course, as I mentioned, state leadership is now itself under attack with the administration's attempts to go after New York's congestion and pricing scheme and the use of California's waiver for regulating greenhouse gases from vehicles. In denying that waiver, of course, Congress is shifting from a long-established paradigm defining what kinds of rules the CRA could reach, subject to the requirement of the Congressional Review Act, and they've ignored counsel of CRS, GAO, and their own parliamentarian in reversing an adjudicatory decision. So perhaps paradigm shift is like too nice a way to put these reversals. I was intrigued by the whiplash example that an earlier panelist used, so maybe we can discuss as we talk other appropriate terms that we might use at this time with the help of these amazing guests who I've had the pleasure of working with over the years in various capacities in my own roles, and I know them to be excellent lawyers and humans. We will hear from David Uhlmann, Bill Buzbee, and Larry Weinstock, and as I've been instructed, I will very briefly introduce them because you have their more full bios in the packets. And we will be starting with David Uhlmann. So I'll just start by saying David Uhlmann is a visiting professor here at George Washington University Law School. He's also a partner at the DC office of the Martin firm. And we served together in the Biden administration where he was the assistant administrator for enforcement and compliance assurance at EPA. So David Uhlmann, take it away.
Thanks so much, Vicki, and great to see everybody here. I too am impressed that we've got such a robust turnout on a Friday afternoon on what started out as a really rainy day, although it looks like it's getting better, which makes it even more impressive that you're still here. So thanks for sticking it out for our panel. It's a delight for me to appear on the panel with Vicki, who is just a fabulous partner. I didn't get to serve for 4 years because I had this little problem of the Senate taking 2 years to confirm me as Assistant Administrator for Enforcement and Compliance Assurance. But Vicki was a great partner and a great friend throughout that time. It's also wonderful to see Bill Buzbee again, who I met when I first joined the Michigan faculty, now a very long time, probably 2 decades ago almost. And I'm also delighted to be on the panel with Larry Weinstock, who I just met last week in our planning call. So I thought I'd talk, we're each giving brief remarks to start out, and then we'll have hopefully a great conversation, including answering your questions. And I'm a big believer in the rule of threes. There's probably 30 things I could talk about paradigm shifts and about sort of where we are, but where I wanted to focus first is the rather dramatic pivot that's taken place at EPA since Vicki and I left the building. Whiplash is gentle, actually. It's almost, the place is almost unrecognizable, at least in terms of what it's purporting to do. I'll say more about that in a minute. I then want to talk a little bit about what's happening across the federal government, but I'll focus on EPA and DOJ and the environmental work that they do and the degree to which, frankly, that's just been the personnel changes are maybe the most significant thing that I will talk about, because they will last past this administration and are sharply limiting. And then, just true to our paradigm shifts, I want to just talk a little bit about enforcement and briefly mention 2 paradigm shifts that I tried to promote during my tenure as assistant administrator, really important changes that I worked with the career staff to implement. And then also, I'll share my thoughts about the shift in focus that's taken place in this administration, which is basically not to enforce the environmental laws, which is a pretty sharp pivot from what we were doing. So those are my 3 topics. Each could be 5 minutes, so I'll give you the 2-minute version of each, or the 1.5-minute version of each. So first up, EPA's pivot. No surprise that EPA would make a sharp turn away from the policies of the last administration. There's a degree to which EPA has been in this unfortunate place now for a couple decades of just of experiencing the shifts back and forth across administrations in ways that I think other parts of the federal government do as well, but maybe not to the extent EPA does. During my confirmation process, one of the things you do is you talk to the senators before you have your hearing. And the now chair of the Senate Environment and Public Works Committee, then the ranking member, Shelley Moore-Capito, said to me during my meeting with her that it doesn't matter who the president is. It just seems like what happens at EPA is extraordinarily controversial. And I'll just say, as a thought experiment, that I don't see why that's the case. I mean, I don't doubt that she's right. I'm sure that's true. We can see it across what's happened over the last 20 years. But it wasn't always so. I mean, if we go back to the 1970s, and even the 1980s, and the birth of the environmental movement in the United States, there was extraordinary bipartisan support for environmental protection. And the environment really doesn't care whether we're Republicans or Democrats, whether we're conservatives or progressives. The changing climate, environmental challenges, they're coming for all of us. So I don't know why we're in this place, and I don't think, since there are students in the room, I don't think we should accept that norm. Although that has very much become the norm at EPA. And the fact that at EPA they experienced pretty dramatic, quite a sea change with the beginning of a second Trump administration was no surprise. But soon after his confirmation, the new EPA Administrator, Lee Zeldin, announced that his role as EPA Administrator, heretofore the agency that was promoting public health and environmental protection for the entire United States. His role was powering the great American comeback. And powering the great American comeback, by the way, what does that have to do with the role or the mission, statutory mission of EPA? But never mind that. Powering the great American comeback still has 5 pillars, one of which was actually environmental. clean air and clean water for all Americans. So, wow, he got the memo, he realized where he was. And he had one environmental pillar. Second, Vicki actually alluded to, promoting cooperative federalism was a second pillar. So we're gonna go ahead and give him full credit for that one because that's a core part of the environmental law construct, although I was on a panel yesterday at an ELI conference where the head of the Environmental Council of the States referred to cooperative federalism in this administration as combative federalism, and I think that's actually more accurate. But we're going to go ahead and give him full credit. I mean, because he got in the ballpark of something that the EPA is supposed to be about. So he's 2 for 2. Clean air, clean water, that's only one because he put them together. And combative/cooperative federalism is 2. But the other 3, here they are. Restoring American energy dominance, that's 3. Making the United States the artificial intelligence capital of the world, number 4. And protecting and bringing back American auto jobs, that's number 5. So look, I challenge you, like, where in the environmental statutes is there any mention of energy dominance, artificial intelligence? We didn't even know what it was, so that's certainly not there. And bringing back American auto jobs. I mean, maybe these are laudable goals. Maybe they're appropriate for an administration to emphasize. They just don't have anything to do with the mission of the Environmental Protection Agency. And so that shift, not to mention the shifts about environmental justice that have already been talked about, ending 30 years of bipartisan support, starting in the Clinton administration, for promoting what should be uncontroversial idea that everyone living in the United States deserves to breathe clean air and drink safe water. I mean, there's more to environmental justice than that, but reduced to its essence, it is that core idea. I don't know why that's so widely controversial or why that had to be eliminated across the agency, but it has been. And so too, I haven't been here for the whole conference, so I don't know how this was talked about, but eliminating the Office of Research and Development, the whole science program at EPA. The whole agency's built up, I'm getting exercised, I'll calm down. The whole agency is premised on the idea of sound science and implementing policy and developing regulations and protecting American communities based on the best scientific evidence available. So what does this administrator do? He eliminates that whole program. Staggering. EPA today, virtually unrecognizable, not just from when Vicki and I worked there, but from every administration that preceded it, even the first Trump administration. That is an extraordinary shift. I don't want to call it a paradigm shift because, God willing, we have free and fair elections in 2028 and we can vote for a different approach, and then maybe we get back to a better place. But certainly that's a huge change. Second huge change, and I got to accelerate my pace here, apologies, but the changes to the federal workforce cannot be overstated, just in terms of how significant the tens of thousands of people leaving the federal government over the last year. This may sound like, okay, well, why do we care about that? We care about that. I mean, thousands of people have left EPA. Hundreds of people, it's only hundreds, not thousands, because it's just much smaller. Hundreds of people have left the Environment and Natural Resources Division at the Justice Department. To put a fine point on the Justice Department, where I served for 17 years before I became a law professor, there were between 120 and 130 attorneys doing civil enforcement of the environmental laws when I was assistant administrator. And they couldn't keep up with the volume of work we were generating because we really amped up enforcement at EPA. We brought in a lot of new people during my tenure, and we were sending lots of cases over to DOJ. And it was so frustrating how slow they were and how much they were staggering under our workload with 120 to 130 people. Today, they're down to between 60 and 70 people for the entire United States. When I was at the Justice Department from 1990 to 2007, they had 160. So that office, the biggest office historically in the Environment and Natural Resources Division, has shrunk by more than half. The office that I led eventually at the Justice Department, the Environmental Crime Section, had, I think, 40 prosecutors when I was the chief of that section from 2000 to 2007. It's down to 20. So the hollowing out of the environmental workforce principally at EPA, but also at DOJ, is an extraordinary shift, and we don't get those people back even when we have a change of administration. Most of them have retired, and look, some of them they were eventually going to retire anyway. But ideally, there's a sort of a passing of the baton that happens over time with new people coming in and learning from more experienced people. We just cut off not all, but much of the experienced workforce at EPA and at DOJ. Decades of experience, we don't get that back. That is a paradigm shift. I mean, we can, I suppose, over time, if we can convince students and others that it's still worthwhile to work in the federal government, that it's a stable place to work, that your job's not going to be up for grabs with every change of administration, we can still hopefully rebuild it, but it's going to take years. It probably will take a decade or more. It took that long, took decades to get that level of experience at EPA and DOJ. And I can't emphasize enough how dreadful that is for the country. I mean, these aren't partisan political people. These are career staff who served Republican and Democratic administrations. They're drinking water inspectors. They're Superfund attorneys. They're compliance officers. That's just in my program. They're policy experts in Vicki program. They're people who dedicated their careers to trying to make the Clean Water Act, the Safe Drinking Water Act work. There are people who worked in clean air programs for decades, and we've just lost all that expertise. And obviously, it's terrible for those people that their careers were cut short, that their public service was so denigrated, as opposed to celebrated as it should be. But ultimately, we're the ones who are worse off because because all of us will be less protected going forward, unless and until we can rebuild that expertise, and it's going to be extraordinarily hard to do. So last, but for me not least, I just wanted to say a few words about enforcement. The enforcement program, we'd gotten the enforcement program to a really good place by the end of 2024. Had our best numbers in a decade. Career staff was, I think, well, before the election at least, super fired up, doing great work. We brought in a lot of new people. We were starting that generational change that I just alluded to. Enforcement has virtually disappeared, at least judicial enforcement, meaning cases brought by the Justice Department. This Justice Department has sued more states than it has polluters in its first year. I kid you not, that's combative federalism. They've sued every state that wanted to do something new in the climate space. They haven't sued polluters. There's still administrative enforcement going on at EPA. Most of that's done out of regional offices that are less affected by policy changes in Washington. So there's still at least a heartbeat in the enforcement program. And it was a pretty good year for criminal enforcement, frankly, because we'd really built up the criminal enforcement program. But in terms of paradigm shifts, I mean, that's more of what I talked about initially, the fact that there's this back and forth across administrations that, someday hopefully we get away from at EPA. But I think the rise and fall of enforcement, that can be turned around. Will be hampered by the brain drain that's taken place. But from a paradigm shift standpoint, I'll just mention first a policy I'm very proud of. It's called the Strategic Civil and Criminal Enforcement Policy. It was a major paradigm shift trying to finally force EPA to have its criminal and civil enforcement programs working together. Huge change, happy to talk about that if people have questions. A second paradigm shift was something called the case urgency policy. EPA takes forever in its cases, EPA and DOJ. So we tried to press to have cases brought within 12 to 18 months, have them concluded within 2 to 3 years. Huge change. And last but not least, because it's the current administration, new policy out of this administration just in December, paradigm shift, I suppose, until it's reversed, hopefully by a new administration. It's what they call the compliance first policy. And it basically says to industry, don't worry about complying with the environmental laws. If we find out you're breaking the law, we're going to ask that you come into compliance. We're not going to enforce against you. We're just going to ask that you come into compliance. Well, what kind of message does that send? Both to law-abiding companies and to those that break the law. I mean, it really says, don't bother with the environmental laws. And holding you accountable will be asking that you comply with the law going forward. So lots of change, lots going on, lots more to talk about. Again, great to be here today.
Great to have you. Thank you so much. So next we will hear from Professor Bill Buzbee, the Edward and Carole Walter Professor Chair and Professor of Law at Georgetown Law. He is also the Faculty Director of the Georgetown Climate Center, and for a long time before that was also our Environmental and Energy Law program.
So the question is, is there a mic here or not? Maybe I need to use your mic.
You can use that.
So I hope it's okay if standing. If I sit, I just hunch over more and more, and finally, after lunch, I just keel over on my nose because I just ate lunch like the rest of you. I'll fall asleep. So first, I want to thank GW for organizing this conference, and Dave, it's good to see you again, and Larry as well. And just second, partly what Vicki told you and David did. It's just great to be also on the panel with my colleague Vicki Arroyo, whose leadership at EPA during the Biden years is amazing. She also earlier headed the Climate Center at Georgetown, which for years was one of the chief places where people worked out problems about climate change. And so at numerous points, Vicki's taught me a lot, and also gatherings she's been responsible for. It led to my understanding how regulation works. So especially thank her. So I've roughly 10 minutes to speak. So here's what I want to do. I thought I'd be picking up on the last panel on market mechanisms, but then they talked mostly about water. So actually I'm picking up more on the first panels talking about kind of shifts on the energy front, and I gather some of the discussions yesterday people talked to me about, which is to focus here on the Inflation Reduction Act, kind of how it was designed, the dream behind it, and then talk about its reception and really, in particular, how well did it work as a way of hardening the world of climate regulation against policy reversals. And I'll explain how that works. And at the end, I'll talk about a particular case being argued Tuesday in the DC Circuit and reflect a little bit on the today's tariff ruling, which bears on everything I'll talk about. So I know that a lot of you are students, a lot of you work in this area. So the Inflation Reduction Act, okay, so the biggest climate piece of legislation ever in the United States, but an unusual piece. And as people have talked about, it was designed completely using regulatory carrots instead of so-called Bugoovian taxes, was designed to incentivize through tax credits, conditional federal spending, spending allocated to agencies and departments to do innovative things. And the idea was to really get things moving despite headwinds on the climate front. So the first thing I'm going to do is talk briefly about the genius of the Inflation Reduction Act, okay? Talk a little bit about the on-the-ground track record, then talk about the Trump demolition crew and what we're seeing, and as I said, talk a little bit about recent cases and what they reveal. So the Inflation Reduction Act's genius, okay? So the first is, it was passed as it was with thin partisan majorities for the Democrats. I think in the end it was one vote. It was passed through the reconciliation process, bypassing the filibuster, because it mainly used fiscal tools. Okay, so but it had within it a lot of programs, and so including some important definitions that I'll talk about in a second. But so the first thing, the genius of it was, it used carrots that got some votes. People saw it, including Senator Manchin, saw it as being a positive force. No one felt they were really losing, except maybe along political grounds. So the law itself kind of nudged things forward in ways I'll talk about. So first, just talking about definitions, the Inflation Reduction Act in 3 different places amended the Clean Air Act to specifically say greenhouse gases counted as pollutants, okay? Now, these were definitions attached to particular new amended provisions of the Clean Air Act, but it did for the first time put expressly in the definition of air pollutant the word greenhouse gases. So a big issue, which I have not yet studied in the endangerment finding, is did the Trump administration grapple with this new reality that this statute changed the text and expressly said greenhouse gases are included. But that was an important little thing. It wasn't a complete victory. It didn't say we wholly embrace Massachusetts versus EPA. but it did create it moved things forward several steps to say the power to regulate greenhouse gases is expressed in the Clean Air Act. Okay, so that's one important thing. Second was, as I said, it worked through not Pigouvian taxes, penalties, but through carrots and supporting spending. And so because it was all incentives and carrots, it basically right away created opportunities. You know, America has many wonderful things and many problems, but it is like a nimble economy and market. And if you put a lot of money out there and say, come and show us you can use it effectively, the United States people respond quickly, and they did. And part of the reason they could was the second work of IRA genius, which is the drafters learned from the Affordable Care Act, the health legislation, or Obamacare. That statute also tried to use money to incentivize progress on the health front, but it required the money to pass through states. And they gave so much money, they thought, I guess, that no states would say no, okay? But a lot of states did say no. So the Inflation Reduction Act learned, and instead it had all of its key provisions. It incentivized multiple entities, private and public, states, new organizations, not-for-profit, community organizations, all could receive money and could even come into being specifically to do programmatic goals of the Inflation Reduction Act. So it bypassed past states as a veto gate, okay? And that was a piece of genius. It was learning from one statute to another during a time of partisan division. And so sure enough, people did immediately receive money, and all across the country, including in red states, where they're generally politically at the state level deny climate change exists. Well, businesses and subunits of government and other organizations and corporations all said, well, we're willing to do something here. We'll open up a factory making batteries and the like. So, okay, so all of this was, this third piece of genius was, this was trying to lock in progress. The hope or the dream was, by getting lots of people across the country moving in the right direction, it would tip the scale enough so the political dynamics would change, and thus there would not be quick regulatory rollbacks or legislative reversals. That was the goal. And on that front, it hasn't worked out as well as people thought, but with some successes. So, so first, how durable has the Inflation Reduction Act been? Well, in the political economic dynamics, as I said, even in conservative states, they did come along, right? And so there are businesses that are still running, even when the second Trump administration came into power and tried to roll things back. There were entreaties from those states to regulators and the White House not to roll back their grants. And when the Big Beautiful Bill, that's what it's called, was enacted, which substantially repealed the Inflation Reduction Act, there were some carve-outs where things kept going. So it didn't roll everything back, but it rolled back a lot. And so, so the idea of locking in people who would resist change, it was a mixed bag. It turns out partisan politics trumped economic self-interest. That's a problem. Okay, but the other is, even with the rollbacks in the Big Beautiful Bill, the Senate parliamentarian allowed the statute to be substantially repealed, but did not allow the excision of the definitions that added greenhouse gases to the air pollutant listing. That was viewed as substantive, and you can't do substantive changes in the law through the reconciliation process. So those remain in the statute. There's not other things going on, but those definitions are still part of the statute. So that is locking in something that will now matter with litigation over the endangerment finding. There's interest for you statutory interpretation geeks, and there's nothing better. You students learn to work with statutes. Okay, but there are interesting issues about how this will be fought. So adding a particular provision when other provisions weren't amended, there's going to be a lot of arguments about how that should be dealt with. And so you should work on your Latin canons of interpretation. Now, let me just talk now. I'm going to shift because I can go like 3 minutes, 4 minutes. How am I doing? Yeah. So let me talk about the regulatory demolition that was going on in the courts, okay? So among the actions that the Trump administration took were first very immediate kind of shout downs of saying stop doing anything that is making climate progress. So there were executive orders and memos and orders to agencies and departments to stop everything. And then there were efforts to stop any new grants, which they maybe could do, that is prospectively. But then the problem was, well, what about all the money that did go out the door already under the previous administration that basically granted people billions and billions of dollars to do things, creating cleaner energy and the like. And the Trump administration did attempt to, people are using the phrase, to claw it back. So I'll just call this clawback actions. And they were basically, we may have given it to you, but this money is held in the particular lead case by Citibank, which in turn allocates the money to the recipients who already had received this money. And so the Trump administration threatened Citibank, threatened the recipients, and claimed they could claw back already granted money. Okay? So this is what's being fought now most in a slew of different cases around the country, but the lead case is a case called Climate United Fund. I believe that's the exact title, Climate United Fund. In the DC Circuit, it's being argued Tuesday en banc. And here are the issues and why it's interesting and why the tariff ruling matters, today's ruling. So the challengers have said, you are seizing our property, we've already received it, without statutory authorization, violating regulations, with no process, with no contemporaneous explanation, violating the separation of powers, and you can't do it. And the Trump administration, Department of Justice, has said, breach of contract. This is only breach of contract, and they are building off of two shadow docket, it's not really clear the majority opinions fully, but short rulings by the Supreme Court on its emergency docket that seem to imagine there should be a bifurcation of regulatory grant cutoffs in certain settings, where some actions could be challenged under the Administrative Procedure Act, and others would be challenged as breach of contract, which go to the Federal Court of Claims, take years, and don't ever provide regulatory relief. So there's these two tracks that the Supreme Court, under slightly different facts, anticipated, and that's what's being fought now. So right now you have before the DC Circuit, are these kind of grant clawbacks, are these unconstitutional? Do they violate the Inflation Reduction Act? Do they violate the Administrative Procedure Act? Do they violate regulations? Do they violate the particular adjudicatory determinations of the EPA? Are they breach of contract cases? All of these issues are swirling about, and these are all very important. Because if it turns out that presidents under their inherent power can just assert the ability to claw back fiscal incentive-based legislation, then going back to my first thing, how durable are fiscal incentive laws like the Inflation Reduction Act? If it can be done readily, that is, if a president without statutory authorization can demolish such programs and grab money back already granted, then this regulatory strategy is dead, okay? That no one will use it in the future. What's important, the tariff ruling today, I speed read it, okay? So interestingly, there's only 9 pages of clear majority opinion in the case. The case splinters with other opinions concurring in the result, concurring parts in the rationale. So figuring out exactly where it all comes out is not clear. But there are a few things that are clear. It is, I think, a very important pushback against the Trump criminal immunity case, Trump versus US. The case, in the part that is clear majority, it says, how is the Constitution structured? Who has what powers? What do statutes say? Where is the express grant of authority? Show us the authority. Show us how it comports with constitutional allocations. And then it goes on in non-majority parts or splintered parts to say, under the major questions doctrine, it's especially suspect here. but how it will be argued will be interesting as you line up justices to see kind of where they are in common. But I do think that this case, I will be shocked if on Tuesday, before the DC Circuit en banc, if there is an extensive discussion and asks for supplemental briefing on this case's implications for how you should interpret arguments about inherent presidential power and the like. I think it will prove very important to this kind of statutory, regulatory battle. And I really do mean to all of you students who are studying this case, like that is the tariff ruling and these cases on grants and environmental law, the masters of law are going to be the really good statutory interpretation experts. Like, I really think you have to sharpen those skills, because it's clear when you all read this case, and I read the opinion fully, it is all fighting about how do you interpret statutes. And so that'll stop there. So thank you.
Thank you. Thank you for reading that on speed reader. And maybe we'll talk about that more in the Q&A, and I'll let other people get in on that point if anybody else here has any thoughts on it. But next, I want to go to Larry Weinstock. As I mentioned, he is a GW Law adjunct professor after many decades of experience at EPA, where we worked together in the Office of Air and Radiation. He was also with Abt and Associates for a time, and he also is an active participant in something called the Environmental Protection Network, which does really great work. A lot of the folks in the EPN, as it's called, are EPA alumni, and so he's one of those. I'm one of those, both as a career person and a political person. And I also want to appreciate Professor Uhlmann's shout out to the wonderful career staff at EPA. And I will note that we have several former government servants, public servants in the audience today, and thank you all so much for your service. And with that, Larry.
Okay, thanks so much. I want to thank the organizers for this, and thank you guys. I'm really pleased to see this many people Friday afternoon. That's really amazing. So I'm going to talk about two things. First of all, the DOE climate report, and then I'm really going to go into the rescission of the endangerment finding and the decision that was done by EPA. And but let's start with the, before I do that, I just want to be clear in my comments that I am not saying that the Republican Party and the MAGA movement are fully owned subsidiaries of the fossil fuel industry, but what I am saying is that if they were, you wouldn't be able to see a difference between what's going on. So the DOE climate report goes along the lines of a American Petroleum Institute memo on global warming. Victory will be achieved when recognition of uncertainties becomes part of the conventional wisdom. And the report basically claims climate change is not a problem. There are many problems with this report. The court decided that it was a violation of FACA. But I want to go into just a little bit more than that. Politico had an article which I recommend to people, how a major DOE report hides the whole truth on climate change. A detailed examination by Politico's E&E News found the report obscures key facts about climate change, relies on outdated studies, cites analyses that were not peer-reviewed. It cherry-picks mainstream research and omits context. It revives debunked arguments in an attempt to cast doubt on long-term warming trends. The result is a report that promotes ideas starkly at odds with the vast majority of scientific evidence. It prompted a remarkable response from the National Academy last week that stated, human-caused emissions of greenhouse gases and resulting climate change harm the health of the people in the United States. I want to touch on that NAS report just a little bit. Just the fact that it happened was amazing. Like, I was in EPA for 37 years, and we went to NAS a number of times. You pay NAS a ton of money, and it takes forever to do this. And those people were so offended by the DOE report that they turned around in a matter of weeks, a report just going through the science on climate change and debunking the crap, let's just be honest, that was there. Carbon Brief had a fact check of the 100 false or misleading claims. Researchers were claiming their own studies were being misinterpreted. Just a couple of examples. The report makes a big deal about the number of hurricanes has not increased. The climate argument has never been that the number of hurricanes will increase. The argument has always been that they will be getting stronger, and that is, of course, actually happening. The urban heat island effect was the excuse. That's why temperature numbers are going up, because we're building up these cities, so we have this urban heat island effect, which of course explains all the glaciers that we've lost, because you know how glaciers are always in major metropolitan areas. So just kind of moving on from that, I think the final kind of nail in the coffin is they would not defend it. They put out a report, they took comment on it, and then they were said, oh, never mind. Like, if they actually even believed that this could withstand any scrutiny, they would actually have responded to comments. EPA included it in their proposal, and then when they go to the endangerment finding, they actually say, oh no, we have no science involved in this whatsoever. So it is important, if you are ever in a situation someone goes, oh, what about this DOE climate report, to just remind them that DOE wouldn't even defend it when it was criticized. Let me go to the endangerment finding. So in 2009, EPA did the endangerment finding in response to Massachusetts versus EPA. They said 3 reasons we know the Earth is warming: measured temperatures, widespread melting of snow and ice, and rising sea levels. And the reasons that we know why it's man-made: physical understanding of the impacts of more greenhouse gases, historical evidence, and computer models. I just want to also, I think it's always important, just throw in a few just kind of basic things, some years to note, shall we say. 1976 was the last year the average land-ocean temperatures on Earth were below the 140-year global average. So we're going all the way back to 76. 1998 was the only year in the 20th century to be hotter than any year in the 21st century. 1970 to 2020 were warmer than any comparable period in the last 2,000 years. 2013 through 2025 are the hottest 13 years on record. And I just want to make a prediction here. 2025 is actually the 3rd warmest year on record, so you can expect to hear climate deniers saying, oh, see, there's, warming is going down because 23 and 24 were hotter than 25. So just look out for that, it'll be coming. In 21, the Weather Service readjusted normal temperatures up based on the last 30-year record. So, when you get the weather report, this is the normal high, normal low. Those were all adjusted across the country. And also 2024 replaced 2023 as the hottest year on record, and was in fact the hottest year in the last 125,000 years on Earth. Okay, so let's go to the rescission itself. The question is basically whether greenhouse gases are a pollutant under Clean Air Act, Section 202A. And the standards are applicable to the emission of any, so these are motor vehicle, motor source standards, applicable to the emissions of any air pollutant which in the administrator's judgment, cause or contribute to air pollution which may be reasonably anticipated to endanger public health or welfare. The definition of welfare in the Clean Air Act. And I want to point out when I go through this list to note that virtually everything on this list is impacted by climate. Soils, water, crops, vegetation, man-made materials, animals, wildlife, weather, visibility, which I might grant is the only exception, climate itself, the actual words climate is in the definition of welfare, damage to and deterioration of property, hazards to transportation, as well as effects on economic values and on personal comfort and well-being, whether caused by transformation, conversion, or combination with other air pollutants. EPA's current position is that the Clean Air Act section is best read to encompass air pollution that endangers human health and the environment through local and regional exposure that domestic regulations can impact without requiring international emission reductions. Secondly, we conclude that the futility warrants repeal of the greenhouse gas emission standards independent from the endangerment finding because they impose immense burdens without furthering any statutory objectives. As I said before, science is not part of the decision. The endangerment finding standards, the EPA's position is that they are de minimis, result in de minimis changes to temperature, and they claim support from Michigan v. EPA, York versus EPA, West Virginia versus EPA, and Looper Bright, and take, as I said, the position that Clean Air Act is only for local and regional problems. I would point out that Section 202, the words local or regional do not exist at all in the statute. The words climate and weather do. So there's a bunch of problems with EPA's position. First of all, de minimis by definition is a technical decision. It is not intrinsically obvious that if you reduce some 50 billion tons of greenhouse gases over the next 28 years, that would have a de minimis impact on the environment. So, and EPA has modeling, and I have searched, I've spent hours looking for it. I cannot find that modeling in the proposal, so that'll be an interesting EPA issue if nothing else, that said to make the point of de minimis. Now, of course, US transportation emissions, they say, are too small. US transportation emissions are the #1 source of greenhouse gas emissions in the country with the #2 highest level of greenhouse gas emissions in the world. They are more than all but 4 countries on Earth. In addition, because of this ruling, that percentage will go up, which I'm confident the EPA's modeling, if we actually ever see it, did not take into account. There's also this little thing called the social cost of carbon, which says, how much a ton of carbon reductions is worth. And we're talking about 1.8 billion tons of greenhouse gases for the years 2027 to 2055, which is around 50 billion tons altogether. I just did this back of the envelope. Under the Trump 1 administration social cost of carbon, that is $350 billion in benefits. Under the Obama $42 a ton, it's $2.1 trillion in benefits. The Biden administration is like 160, so we're talking multiple trillions in benefits, which are de minimis. The administration has taken the position they're not going to have a social cost of carbon because it's too uncertain, which they just made as a statement. There is no technical support for this whatsoever. The point of EPA is that the 1% warming that they calculate is de minimis, which flies in the face of multiple EPA examples, such as the Good Neighbor policy, which was 1% of, and if one state had impacted the ozone or PM problem by 1% in another state, then they had to control. There's also these things called control technology guidances, or CTGs. That's part of the RAC system of controlling VOC emissions in ozone non-attainment areas, and there are 46 of them. Now, when you consider how much VOCs come from cars and major sources, there is no way that those 46, it's just mathematically impossible that they all have more than 1% impact. Also, and this was something I read, but it's like 1 million there are 3 million deaths a year in the United States. 1% of that is 30,000 deaths. You wouldn't say that was de minimis. I wanted more problems with EPA's position. Mass versus EPA clearly told EPA to make this determination, and they even specifically, in the opinion, state that the idea that you're only taking a small part of the problem and working on it is not an excuse, because all problems, you start with small pieces and you put them together. Okay. Yeah, okay. So I could go through the other cases. I won't to save time. I do want to really focus on the dishonesty and the bad faith around this. They claim, and they were very public about this, and Trump personally was public about this, $1.3 trillion in savings. Now, they get those savings only by a, this, as far as I can tell, made up number of $2,300 cost in the price of a new vehicle. And if you look at the regulatory impact analysis, you will see that the table where they have this calculation, and this number appears, there also underneath it are costs of the repeal. And the net, it's not savings, it's a net cost to American society of $180 billion in the exact calculation that they claim this $1.3 trillion in savings. The EPA asked the Energy Information Administration to do a specific run on the energy impact and it found $4 trillion in net gasoline, additional cost increases, prices going up as much as 76 cents a gallon. They talk about EPA getting rid of consumer choice, but when the standards went out, the greenhouse gas standards went out, they allowed from 60 to 40% of the cars sold in the United States to be gas powered. And what they're doing is actually trying to eliminate EVs, so they are the ones who are actually getting rid of consumer choice. They're literally lying about EVs. They talk about how Americans prefer performance over efficiency, which is probably true. But the thing is, and I say this as the proud owner of a EV, these things have instant torque. They are the most powerful cars you can have unless you are going to spend serious money on like a Porsche or a Lamborghini. And in fact, they are cheaper to own. They have fewer moving parts. You never change the brakes. There are no oil changes. They are just maintenance, and also electricity is cheaper than gas. So with that, I will just hold off.
Okay, thank you. I like my bolt too. I think I'm going to go to Professor Glucksman.
So just 3 quick comments that build on some of the panelists' remarks, and maybe the panelists will want to respond to my third comment. So Mr. Uhlmann talked about the formerly bipartisan nature of environmental law over the past 55 years. I just want to bring to your attention 2 remarks made by 2 previous EPA administrators. First of which was Bill Riley, who was the EPA administrator during the George H.W. Bush administration. He said, we can't allow what's going on now to be regarded as normal. It's not normal. The second was a remark by Christine Todd Whitman, who was the EPA administrator under George W. Bush, his first EPA administrator. She said, I don't understand how it's possible that the Environmental Protection Agency has become the enemy of the environment. So it once was bipartisan, and some of the holdovers still think it should be. The third remark I want to make is that there's an entire field of environmental law that wasn't really addressed by the panel, and really kind of not by the entire symposium, which is federal public land management. And what's happening in the pollution control field is being replicated on the natural resource management side of things. So Professor Uhlmann talked about Lee Zeldin's comments about what he thinks the function of EPA is. The analog on the public land side is Doug Burgum, who's the Secretary of the Interior, who defined his mission as driving a dagger into climate change ideology. This is the Secretary of the Interior. That's what he regards his function as. To pick up on something that Professor Weinstock said, which is maybe one of the parties, major political parties can be regarded as a subsidiary of the fossil fuel industry. What's going on in public land management is all about promoting coal mining, oil and gas drilling, and hard rock mineral extraction. And they're sometimes occurring close to protected areas like wilderness areas, and sometimes smack in the middle of sensitive areas like wildlife refuges. And so I think we've got the same thing going on in the public lands context as we do in the pollution context, and I don't know if any of you wanted to comment on that.
Anything to add?
I just want to, as someone who's in EPA for 37 years and started in the Reagan administration, you could have asked anybody at EPA and they said, what is your mission? And it was to protect human health and the environment. And that is clearly not what the leadership of EPA feels now, but I just think it's important that this is what an entire 15, 16,000 people all saw as their job. And they're trying to change that now.
I mean, I'd add simply on the EPA side or the environmental side, I mean, there's room for policy differences and disagreements. So when I say we've got to do something to reclaim bipartisan support, when I lament the loss of it, I'm not saying we have to have groupthink and everybody's got to think, it's one size fits all, that we've all got to adapt. But I think the core commitment, which Professor Gutzman is referencing, and which Larry's referencing, this core commitment to the ideal that a healthy environment benefits us all, that public health is a priority for the country, like that shouldn't be up for grabs. And I think that's what's so disappointing about this. I do appreciate the reference to public lands. I don't know that people realize, particularly East Coasters, there's public land in the East Coast. But in the West, it's more than half the land. And the federal government's role as the steward of that land and its ability to steward that land in a way that's sustainable and protects it for future generations is also up for grabs. So thank you for pointing that out.
So the only thing I'd add is a shout out to administrative law. Okay, so I know it's what everyone's thinking. Let's talk administrative. So I do think it's important to look during the time all this demolition by the Supreme Court of a lot of precepts about constraints on government, and then you have the White House doing a lot too. But there also are certain strains in administrative law that are strong or have actually been strengthened in recent shifts that maybe are important bulwarks that especially you students will use when you're out there practicing. And the first is the statutes on the environmental front and the public lands front are either protective or require protection of mixed uses. That is, they don't generally authorize wholesale demolition that doesn't look at science. And so even under the Roberts Court with their shifts, they said government has to show an action is authorized by the single best meaning of a statute. Okay, that's this Loper-Bright case. So anyone challenging a Secretary of the Interior who's talking about grounding actions and something that has nothing to do with their statutes, the action may be subject to attack. Also, there's a doctrine called policy change, or the Supreme Court called it change in position doctrine. And that is when an agency shifts policy, these heightened obligations to explain and confront facts and science and past rationales. All of these actions are against a backdrop of past action. So everything that Larry, David, Vicki, and others talked about that has gone on in past years, the Trump administration does, if they're going to be lawful, need to grapple with these realities. They can't just blow past it. So I would say just during times that are mostly dark, these are areas of administrative law that remain strong. They have not been cut back on. And so, and today's tariff ruling also is very serious about what statutes authorize. So kind of restoring the core parts of administrative law and statutory interpretation maybe are an effective counter because the statutes tend to still be pretty protective.
Alex.
Thank you. So my question is for Bill. You did a great job teeing up the different statutory interpretation questions. It was curious to me that you didn't answer any of them. I didn't provide that. So given that this isn't a class, I thought maybe I would put you on the spot and say, what do you think are the appropriate interpretations given the many the canons of interpretation that you write and teach about?
Yeah. Well, I mean, so first, you have.
Wait, he just failed you, I think.
No, but see, you got to keep something out there for people to think about. It's like a movie preview. If the preview tells you too much, you've ruined the movie.
This is not the preview though. This is the movie.
Okay. So first on the endangerment finding, the endangerment finding is flatly contrary to Massachusetts versus EPA. And so I think Larry pointed out all the flaws of it, but it is just completely, I think, a Hail Mary pass asking the Supreme Court to reverse Massachusetts versus EPA. And where I think all this matters is on the statutory front, when Congress legislated Massachusetts versus EPA was the law. So the law already said when it came to motor vehicles, greenhouse gases are included. And then there was an issue, okay, we're doing more things, and they added in specific authorization for greenhouse gases. So I think under normal, both what's called vertical history, tracking a law over time, but also comparing provisions, I do actually think that there is a strong argument, a stronger argument now that Massachusetts versus EPA should be upheld. But that's all assuming law matters. I mean, that's the big issue is the current Supreme Court much more cheerleaders for this administration, or do they take statutes and administrative law seriously? That's why I think that today's immunity decision is important, it really, and I encourage you all to look at it, you'll just notice they keep saying the Constitution allocates this power to Congress, this power to the president, this statute said this, it didn't say this, and so it's very, it's kind of parsimonious and kind of saying, show us your power, and so I think putting these together, I'm not despairing, okay, but I do think, the other side, the other side is going to try to say they didn't change all the definitions. And so they're going to say they knew it was contested. If Congress wanted to expressly authorize other provisions, they could have, and they didn't. That's also a move the court, Justice Scalia used to like doing. But here it's a little different because you have Massachusetts. So.
Do you think today's kind of split opinion on major questions plays into that? And
Yeah.
does it help or hurt those of us who want the endangerment finding to stand?
Well, there's two things. There's Massachusetts versus EPA and what it says, and there's also Michigan versus EPA, which is costs and benefits. And so Supreme Court has stuck with that. So you put all these things together in the endangerment finding, for them to succeed, they're going to have to show they looked at the cost and benefits of this action, both sides of the ledger, and dealt with it reasonably. And then they have to show in some way that there's something that was really worth overruling in Massachusetts, which is an additional burden of justification. But looking at today's split, Justice Barrett writes an opinion. She doesn't wholly say, I don't believe in the major questions doctrine, but she basically says, don't read too much into, she says something like, I don't buy into that project or something. And she drops a footnote and says, I believe in looking at the objectified intent of what Congress said. So she's ends up being almost identical to Kagan. So then you have four who have disavowed, basically, major questions. And then you have Roberts taking I'd say, a pretty fair-minded read of the statute, as he did in King versus Burwell, if those have read it, which is a fair reading of the legislative, or fair understanding of the legislative plan. And so I think that major questions may be subsumed a little more into Loper Bright, just sound interpretation, because in the end, this opinion, it isn't clear they needed major questions, but we'll see.
Yeah.
Other questions?
I just want to
while Larry's responding, I hope some students raise their hands. I'm just saying. Okay.
I just want to make the point that I just touched on the iceberg portion of all the problems with the endangerment findings, so I don't want people to think there aren't way more. But as far as the major questions, I do want to point out that facts sometimes matter and sometimes don't, because in the major question in West Virginia v. EPA, Roberts waxes poetically about all the damage that's going to happen if we drive the amount of coal, electricity produced from coal to 27%. And the year before, the amount of electricity produced by coal was not even 22%. So we'll have to see how that goes.
Okay, here's your chance for extra points. I'm going to give you extra credit, and I don't even teach here.
Your credits aren't.
They're not fungible. I think they are. After
credits.
that market-based panel, I'm feeling like we can make this happen.
Well, can I just make one separate point, which is Jesse and earlier, I'm trying to, there was another, two people talked about the topsy-turvy nature of all these reversals. You said it was a tornado. And so one of the interesting twists in how this is all playing out is all of these regulatory reversals come with lots of costs. And so one issue is, has this Trump administration really confronted in a genuine and persuasive way with facts explain the realities of the effects of these reversals. That's another area where the Supreme Court has not abandoned its fundamentals. In a case called Ohio versus EPA, a single critical comment that EPA didn't respond to was enough to throw out the action. And in these recent actions, there isn't even much of an effort to really address the topsy-turvy nature of these policy reversals.
I have a question for you, Vicki, and maybe this is something that some of the students in the room aren't completely aware of. You talked about the Congressional Review Act and the extent to which the Republican Congress in the last year or 13 months has reversed a series of Biden administration actions, including some that would not have normally been regarded as rules. And some of those include, to get back to my public lands point, land management plans issued by the Bureau of Land Management, which traditionally have not been regarded as rules. But it's more than just reversing things that have already happened. I wondered if you could talk a little bit about the implications going forward, given the provision of the Congressional Review Act that basically says that agencies that have been reversed under the CRA cannot adopt a rule in substantially the same form going forward.
Yeah, so one of the roles that I had at EPA was to be, as I was over the policy office, over the group that did a lot of the policy making apparatus, in addition to commenting substantively on the media office's regulations. And so that meant that we had the people who actually got the materials to the Federal Register and then delivered in person, even during COVID lockdowns, the rules to the House and Senate and to GAO per the Congressional Review Act. So we were very careful about understanding what those requirements were, because there's a certain amount of time, I think it's 60 legislative days, that Congress has to act. And we were cognizant of the fact that if things changed with the election, that some of the rules that people had been working hard on for years could basically be undone very quickly. And so we worked very hard and diligently to get those in, but we also knew what the interpretations were all along the years, over the years, Republican and Democratic administrations, that certain things fell under that Congressional Review Act, and it could be a pretty broad view of what regs looked like. It could even be guidances, for example. So if you really wanted to protect them, you tried to kind of get that in before that deadline, which ended up being, I think, in August, but I think originally we thought it was going to be like May. But we weren't doing things like delivering the waiver decisions because that had been adjudication and understood that that is not something that Congress could reverse in that way. And I guess that happened in other departments too, as you say. So I don't have a line of sight to how you cope with that new scenario, other than just to say that a huge part of my job in the last year was really trying to get ahead of these deadlines and to work with our colleagues across the agency to get them done, to get them published in the Federal Register, because that's part of the deadline, as well as the delivery dates and all that. And now you have the scenario where it seems like anything could go there, right? If you're really starting to introduce things like adjudications, what about permits? What about other things that you thought were open and shut cases? Where does it end, right? So I'm scratching my head if I had that role now, not in this administration, but in a future administration, about do you send things that you really don't think should be sent over there just to kind of protect them, but then you're starting to feed into this notion that all of that should be subject to the CRA. But I think it's a very fair point. And the point that you really can't do anything substantially similar constrains you, even though ironically, obviously, all these regulations are being put into force anyway because the statutes tell you to do that, right? And we're often well behind on what we should be doing as regulators in these positions. The statute tells you to do a certain, air reg or, hazardous waste reg or whatever in a certain amount of time. We're behind that statutory command to do it, and then you're basically told, oh yeah, don't do it that way, by people who look at it very briefly compared to all the process that goes into building up the rule in the first place. And then you can't do anything substantially similar. So then that begs the question, what do you need to do at that point? Because you've got this reg still on the books. This law still on the books telling you that you have to be protective. And then, basically these handcuffs that aren't allowing you to do your job. So since I'm not in that position now, I'm not really thinking too much about that day to day. I'm thinking more about land use law and the things that I'm teaching. But I think these are really great questions, and it just shows you that things that might seem expedient at the moment really can open up a Pandora's box so that the same administration might not be happy about what ends up happening as a result of this change that now they have, put out there into the world. Others on that? Maybe David?
There's a hand up in the back.
Okay, yeah, let me just go to David, you want to get in?
Oh, I think the last thing you said deserves just highlighting. I mean, careful what you wish for. I think this administration has thrown out norms left and right. I mean, they're distorting policy doctrines. They're distorting process. They're declaring emergencies. They're, just sort of everywhere you turn, and they're doing it all in a way that overwhelms us, right? There's so much, the volume of it, you can't keep up with it. And even if they don't get away with all of it, there's so much of it that they feel like they're gonna get away with some of it. I mean, it's I suppose, diabolically brilliant in its execution, because they're destroying a lot. But the tools they're deploying can be deployed by others as well, to reverse all the things that they did. And at the end of the day, what ends up happening is, we lose the center, we lose the role of the rule of law, which has served us well for 250 years almost. And I think, I think we need to get back to a place where we try and find bipartisan support for environmental protection. I think we're also gonna have to come back to a place where we have some boundaries on what's acceptable and unacceptable behavior. And it's gonna be a huge challenge, right? There's a Pandora's box problem here, there's a Humpty Dumpty problem, I don't know, whatever metaphor you want to use. But it's a really important point.
So I think we have time for one more question and a quick response.
Thank you so much for this opportunity, and I really enjoyed the session. Thank you so much for the lovely input. I just have a question regarding the international landscape. We are seeing that there are domestic clawbacks, and the administration is rescinding contracts on domestic level. Do you think this can potentially lead to international litigation as well, where there are investor-state disputes with international, with international parties involved? And we're foreign investors. Do you think this can also lead to international litigation as well with this?
Does anybody want to do that?
I hope my question's clear, though.
It's clear. I'm not sure that we're the right people to answer it, but
Yeah.
but I'll give them a shot. Anybody?
I mean, there should be, but we don't recognize, for example, the jurisdiction of a lot of international bodies. I mean, that's another aspect in which there's just been so much destruction over the last 14 months and beyond. So sure, we are not an island. We are part of a world. We're part of climate change didn't go away because the President of the United States doesn't believe in it. Environmental problems, energy problems, ecosystem problems, all the different things that have been talked about in this conference, none of them went away, and they don't just affect the United States. So absolutely, you're right to call attention to the broader international dimensions. But the United States isn't great on this topic. We're not great on really recognizing other forums and their ability to control our behavior.
I would add just one thing, which is a lot of the rollbacks are undercutting contracts that involve, as Jesse's company, that companies have U.S. subsidiaries and parent companies abroad, and very often goods and parts of things being built, from batteries to wind turbines, are part of international supply chain. So although I think a lot of this stuff should be battled over as a regulatory matter, there clearly are contract claims that will be fought over. So that's an additional cost that I think this administration assumes they won't pay for. The taxpayer will, or the year is off, there'll be a moment of reckoning. But I would be shocked if there were not breach of contract claims being filed all over, being prepared, unless they're afraid that they'll be punished for bringing suits, and that it's just out of intimidation worries. But I think that will be, before international tribunals, just be a lot of skirmishing about recovering lost money if projects are killed or undercut.
So please join me in thanking this panel and thank you for Professor Bronin.
Thank you so much, everybody. And I am going to take just 3 minutes, I think, to conclude these 2 days of wonderful dialogue. The last panel did include a bit of a partisan critique, but I do want to emphasize what we've heard for the last 2 days, which is electrons, water, air, sunlight, wind, these natural resources that sustain us and that we need access to have a cleaner future, do not care about partisan boundaries. And what I love about the conversations yesterday and today was what united the speakers, which is that in different ways, they have all worked to support the environment, our air and our water, our flora, our fauna, our planet, and our homes. And they've done that throughout their careers. Through research, certainly, we had a healthy number of professors, but also through public service, through timely commentary, through regulation, and through construction, including of energy projects. So over the last 2 days, we covered, of course, statutes in energy and environmental law, NEPA, the Clean Air Act, Clean Water Act, Federal Power Act, even a little mention of the National Historic Preservation Act, as well as, I wonder who put that one in there, as well as executive action. But I hope members of the audience over the 2 days came to understand that there are a range of other laws and legal doctrines at play. So liability rules, liability rules, a breach of contract, administrative law, separation of powers, antitrust, criminal liability, and yes, property law. The speakers also covered an incredible range of topics. Climate data, congestion pricing, water markets, community power, citizen involvement, mitigation, cooperative federalism, and market incentives. So for the students in the room, it's really important to note that the best lawyers know how all of these different areas of law actually work together. Because you might find yourself needing to deal with energy and environmental issues when you have clients that are banks, are private companies, real estate developers, sports teams. I know there's some sports law folks in the audience, and so much more. So I'm really glad you are here to bear witness to that. The Supreme Court's decision in Learning Resources today really underscored the point of the conference, which is that energy and environmental law are incredibly dynamic fields. They are changing and they will continue to do so, even as we were talking about the very issues that the Supreme Court covered today. That's why the speakers really delved into not only the role of laws, of regulations, of litigation, of courts, judges, and of course the role of lawyers. So just to conclude by saying we need lawyers. We need lawyers to be involved in these conversations, to write the rules that protect our environment, to interpret those laws through regulations and guidance, both through public bodies and for private actors. We need lawyers to challenge the laws, policies, and executive actions that aren't working to meet our priorities. We need lawyers to design administrative systems that put incentives in the right place and that provide clarity and certainty to those that are governed by those systems. And as we heard in the last panel, we need effective enforcement regimes. Those are designed by lawyers too. So thank you to all of the speakers for helping to contribute to a vibrant intellectual community here at GW, and we really hope to see everybody soon. Goodbye.